morning. This is an Asian session, so we are very punctual. We start 10:30 exactly at this time. So welcome to the panel on data transfer between EU and Asia to celebrate the Data Privacy Day. Data Privacy Day is no longer the European day. It is also an Asian day because in Japan we had a big event to celebrate Data Privacy Day in Tokyo. Well, my name is Hiroshi Miyashita, a law professor at Chuo University. Well, this panel is to explore the issues. Number one, what are the practices of data transfer in Asian jurisdictions? Number two, what is the impact of European Court of Justice's ruling, Schrems case for Asian countries? And number three, how we can ensure an adequate level of protection for data transfer between the EU and Asia. Well, privacy is local. The information flow is global. This is why we always face the difficult question on data transfer. Well, data transfer is one of the most controversial issues on data protection, particularly since after the Schrems case. What we have seen from the Atlantic debate between the EU and the US is crucially important for the Pacific jurisdictions, since the sea is connected between the Atlantic and the Pacific. Well, in the Asian jurisdictions, the balance between free flow of information and the protection of personal data is very important, as here in the EU. Yet, during these 2 decades, no Asian jurisdiction is officially regarded as adequate level of protection from EU. In addition, European Commission listed 79 global companies which meet the binding corporate rules, BCRs, but not a single Asian company is certified so far. But last year, both Korean government and also the Japanese government expressed their interest in applying the adequacy finding. Some Asian companies are also interested in seeking the binding corporate rules. Southeast Asian countries have adopted the new privacy legislations, including data transfer restrictions. In the cross-border context in Asia, APEC, consisting of 21 economies representing approximately 57% of world GDP and 47% of world trade in 2012, set privacy cross-border rules. So-called CBPRs, APEC cross-border privacy rules, require participating businesses to develop and implement enforceable data privacy policies consistent with the 2005 APEC privacy framework. Last Monday, 25th January, the Japanese privacy seal organization, JIPTEC, was officially recognized as an accountability agent, and the Japanese privacy seals practices over the 2 decades, nearly 2 decades, may widen in the APEC regions in the future. At the same time as the official paper published by the Article 29 party in February 2014, APEC CBPRs and the EU BCRs have been seeking the interoperability in the future. In the context of trade, TPP, Trans-Pacific Partnership, was signed by 12 countries last October, which triggers another data transfer problems. E-commerce chapter provides rules on data transfer, namely, each party can adopt or maintain the measures on data transfer restriction to achieve a legitimate public policy objective. In addition, TPP prohibits so-called data localization. No party shall require to relocate computing facilities in that party territory as a condition for conducting business. Well, these trade rules, binding rules in the Pacific Ocean, may bring some impacts on the data transfer in the near future. Well, without further ado, I will leave Isabelle, who is the head of complaints and litigation in the supervision and enforcement unit of EDPS, to moderate the panel.
Thank you very much, Professor Miyashita. I have been asked to start the session by giving just a short introduction on what are the rules for transfers in the EU before data can actually transfer to Asia. What are the minimum requirements that we are looking at from a European perspective? And I suppose a lot of you are already familiar with that. We have in Europe a strict regime for data transfers. It's organized in Articles 25 and 26 of the Data Protection Directive. And basically the principle is that for data to be transferred outside of Europe, there must be an adequate level of protection in that non-European country, or else the transfers is only allowed if it falls within specific types of exceptions. Basically, the EU regime on data transfers is designed on the principle that the protection that is afforded to the personal data in the EU must, to a great extent, follow the data wherever they travel. And we must also interpret this strict regime on data transfers in EU law in consideration of our EU legal order, where data protection is a fundamental right guaranteed under Articles 7 and 8 of the Charter, and therefore seeks a quite high level of protection of the personal data. And this is also something that was confirmed by the Schrems judgment, that the judge has looked not only at the provisions of the directive, but put them in context with respect to this high standard for data protection that is required from the Charter. So, as I mentioned, usually there are three main ways to do transfers to non-EU countries. The first one is the country is recognized as being adequate, and this is organized under Article 25 of the directive. There is an assessment that is being conducted by the Commission, and then the Commission adopts a decision recognizing that the laws and the practices in that non-EU country offers an adequate level of protection, and a few countries have obtained such adequacy decision, for example, Switzerland, Argentina, New Zealand. If there are no adequacy in that country, transfers, as I said, can happen by way of exception. If, for instance, the controller adduces adequate safeguards to ensure the protection of fundamental rights and the exercise of those rights. Typically, this has taken the form, for example, of mechanisms that have been developed, which have been mentioned. The binding corporate rules, for example, is one of them. Standard contractual clauses are also a mechanism for transfer that has been developed by the Commission. There are a few that have been approved for different types of transfers. Also, there can be ad hoc clauses that are adopted on a case-by-case basis between an importer and an exporter. And the third way that transfers is authorized under the law is also by way of derogation. There are a number of derogations listed in Article 26.1 of the directive. But the interpretation that the data protection authorities give to that is that, of course, since there are derogations, they don't apply to massive transfers, repetitive transfers, or structural transfers. So they would apply only in a very limited instances. And if you are not yet familiar with that, there is an Article 29 party paper on transfers of personal data, which dates already from 1998, but which gives a lot of good information on these tools. And before I pass the floor to my colleagues, I just wanted to mention 3 points to think about when we are talking about transfers to non-EU countries, particular transfers to Asia. What can we learn from the Schrems judgment? And so in that judgment, the court declared invalid the adequacy decision that was given to the US. One of the main grounds was that in its assessment, the Commission failed to actually declare that the whole legal system in the US was in itself adequate, and therefore the decision was invalid. So 3 points we can learn from it is, for example, when we look at adequacy, the court says the notion of adequacy means that it is not identical to the one that exists in Europe, but it has to be essentially equivalent. And in this notion of essentially equivalent, The court says that it must be understood as requiring the third country to, in fact, ensure by reason of its domestic law or its international commitments, a level of protection of fundamental rights and freedoms that is essentially equivalent to that guaranteed within the EU by virtue of the Directive 95/46 read in the light of the Charter. So that's the first point when we look at adequacy. A second point we should also look at is that the judge went into looking at whether the law in that third country may impose restrictions on the fundamental rights that are so critical, so invasive, that they are actually compromising the essence of the right to respect for private life or for respect of data protection. And in such cases, it is such an interference and it's so serious that for the European perspective, it cannot be an interference that is justifiable under the Charter, and this probably would put at risk the transfer of personal data in that country because the fundamental rights there might not be guaranteed. And I think this will likely lead to more scrutiny from the regulators of the legal environment of the country to which data are being transferred, to verify that the laws there are not affecting the essence of the right to data protection, or whether they would be posing an interference to those rights that goes beyond what we consider in Europe as being necessary and proportionate. A third point I wanted to mention also is that from the judgment we see that data protection authorities have a very important role to play also in respect of data transfers, and they do have to ensure the protection of the individual's rights in that context, and they have a strong role to play also in the enforcement of these individuals' rights. Just to finish off, you know that currently there are discussions in the Article 29 Working Party on the implications of the judgment with respect to the transfers in the US, including the impact of the judgment on other tools for transfers, such as the BCRs and the standard contractual clauses. And we believe that these analyses and the implications of this judgment of course, is looked at right now with respect to one country, but of course has also to be looked at for other countries and what other implications are for non-EU countries around the world. So that was my short introduction on the background, and I would like now to pass the floor to Professor Abu Bakar Munir, who is an internationally renowned scholar, expert and consultant on ICT law and data protection law. He was the Dean of the Faculty of Law of the University of Malaya, Malaysia, and currently is a Professor of Law at the faculty and an Associate Fellow at the University of Malaya Malaysian Center for Regulatory Studies. Please.
Thank you very much, Madam Chairperson. Thank you very much, Professor Hiroshi. And I would like to thank the organizers for giving me the opportunity to share my knowledge about the position in Asia, because I'm sure the discussion here is dominated by discussions on Europe especially, and let's talk about Asia. And I think this session is quite important, given the fact that there have been saying by world leaders that Asia is the future, or the future is in Asia. And it is important for us to know what is the position in Asia with regards to data transfer, especially between Europe and Asia. So, being a first speaker, my duty is perhaps to set the platform, set the stage, and perhaps from there we can discuss specific issues. This session have got 4 main objectives, but my presentation perhaps will try to address 1 or 2 of those issues set for these sessions. And for the purpose of today's discussion, I prepared a small set of PowerPoints to make things easy. And let's get started. Okay, have a look at this privacy world map. I think this is quite common and around the world. Basically, dark blue color represent countries which have got legislation, specific legislation on privacy and data protection. Light blue, countries with draft legislation, and the other color, countries with no legislations, and gray represent countries with no data. So the source is from UNTAD. Perhaps UNTAD doesn't have data about countries in gray color. And you know, Asia, you can see data protection is quite new in Asia. Malaysia enacted the law in 2010, followed by Singapore, and a year before that, Philippines enacted a comprehensive law on data protections. And of course, Korea, Japan, and Hong Kong are quite mature in this area of data protections. And as far as approaches are concerned, I think we can divide the approaches adopted by countries around the world into two. One is based on adequacy, as mentioned by Isabelle, and as mentioned by Professor Hiroshi. It is basically based on the European directive, and of course the second approach is accountability approach based on APEC privacy framework. There is a specific provision in one of those articles in APEC privacy framework focusing on accountability approach. So again, there are two main approaches adopted by countries around the world to protect personal data. Let's have a look at countries in Asia, not all, some of them. Okay. If we look at Malaysia, for example, Malaysia has adopted basically EU's approach, adequacy. And Singapore adopted accountability approach. Similarly, the Philippines, the law in the Philippines adopted accountability approach, Taiwan, as well as Japan. Okay, these are the approaches of countries in that part of the world, or in our part of the world, some of them, in terms of the regulatory framework, what kind of approach that has been adopted. So out of these countries, as I said, Malaysia followed EU's approach. Basically, the law in Malaysia, okay, before I move on to that issue, we know very well this Schrems case, and perhaps later on we will discuss this issue. And these are the laws. I'm not going to discuss in detail the provision of the law, but suffice to say that, as I said, Malaysia adopted EU's approach. Basically, no transfer of data to outside Malaysia unless specified by the minister, and the minister will specify based on whether or not there is a similar law like a Malaysian law, or there is a law that serves the same purpose as the law in Malaysia. That is the rule in Malaysia. And of course, there are exceptions to that rule about consent, legal proceeding, and other things. And this is the law in Taiwan. Article 21 of the PIPA, as I said, adopted the accountability approach. As long as someone can be held accountable in the data transfer, then the transfer is allowable. This is Korea, the same thing. The requirements that apply for international transfers vary whether the data transfer constitute a third-party provisions or as outsourcing. Singapore, and again, the law in Singapore in section 26 says no cross-border data transfer of any personal data to a country except in accordance with the requirement prescribed under the Act. And interestingly, the law in Singapore does not prescribe a specific mechanism to allow companies in Singapore to transfer data. But in the guideline issued by the regulator recently, as far as transfer involving parent company and subsidiary companies, BCR is specifically mentioned in the rules or in the guideline issued by the regulator in Singapore. Philippines, Section 21 of the Data Privacy Act basically does not prohibit the transfer of data to outside the country or outside Philippines. And as long as someone can be held accountable when the data is transferred out of the country. And of course, similarly, there are provisions allowing for exceptions or exemptions where the data can be transferred. So transfer from Europe to Asia. The issue or the question needs to be asked is this: whether the laws in those countries provide adequate protection before data can be transferred, before data can be accepted, or companies in Asia can accept data from Europe, because of the Article 25 mentioned just now requires that before data can be transferred to outside Europe, there must be adequate protection. So the question needs to be asked is this: whether or not the laws that I have mentioned just now, briefly mentioned, are adequate. We will discuss that afterward. And of course, I'll stop here. Perhaps we will discuss the detail and specific issues after.
Thank you very much. Yes, we will continue this discussion as a second round. But for now, I would like Mrs. Hee-Eun Kim to speak about the practices in Korea. Mrs. Hee-Eun Kim is a legal counsel at Samsung Electronics Europe. She's specializing in antitrust, privacy and security, IP law and policy across Europe. And prior to joining Samsung, she was an attorney at Covington and Burling, handling competition and IP law issues for global IT and life science companies. Please, the floor is yours.
Thank you, Isabelle. We have very interesting discussion so far. Today, I'll briefly talk about how Korea is handling this cross-border data transfer issues after the Schrems ruling. In particular, I'll focus on the Korean government's announcement about a month ago to apply for the European Commission's adequacy assessment. Today I'm speaking in my personal capacity, so the opinions I present here do not necessarily reflect the views of my employer. Just to mention this. So a starting point is to ask whether Korea is directly impacted by the Schrems ruling. Although I have not seen an assessment specifically about the impact of the ruling on Korea, my general observation is that the ruling does not have direct immediate impact on Korea, insofar as the ruling primarily concerns the data transfer regime between the EU and the US. However, in practice, just like most companies doing business on a global scale, Korean enterprises may be indirectly affected, for example, in relation to their use of third-party service providers like cloud servers, and intra-company data transfer involving EU-US data flows. So how are companies like Samsung dealing with this? For now, by closely monitoring the ongoing negotiations between the US and the EU about the revision of the Safe Harbor Agreement. And more importantly, we also do our best to ensure that we are duly covered by appropriate alternative legal alternative transfer mechanisms. So for your background, this slide is a snapshot of the trade relationship between the EU and Korea. Both are very important trading partners of the other. For Korea, the EU is the fourth largest export destination after China, the US, and Japan. And for the EU, Korea is the eighth largest export destination. If you see the 2013 statistics here, this is the EU-Korea trade and services statistics. The dark part here shows the surplus that the EU has vis-à-vis Korea. So that's about a 5 billion euro surplus that the EU is receiving from Korea in trade and services, which is likely to involve some kinds of data transfer because it concerns services. So this shows that the common data transfer for many Korean companies doing business in Europe or vice versa, meaning European companies doing business in Korea, is basically data transfer between data flow, sorry. Between the EU and Korea, so enhancing and stabilizing the EU-Korea data transfer regime is a priority. So currently there's no safe harbor-like agreement between the EU and Korea, nor is there a formal decision from the European Commission recognizing that Korea has an adequate level of personal data protection. Therefore, companies must rely on other legal grounds, such as the model clauses, BCR, or exceptions and derogation that Isabelle mentioned. As you know, both model clauses and BCR require approval from individual European data protection authorities. So these can be a significant burden for especially small companies with limited resources. And let me also briefly mention that the EU-Korea Free Trade Agreement has some elements concerning data transfer, the so-called Annex 7D of the EU-Korea FTA. This is about additional commitments on financial services sectors. So one of the commitments on the part of Korea under this Annex 7D was to allow multinational financial firms in Korea to transfer financial information, including customer data, meaning personal data, outside Korea for offshore processing or regulatory reporting. So Korean industries, policymakers and academia have told the government that we need a better mechanism for cross-border data transfers, such as the Safe Harbor Agreement or adequacy decision from the Commission. So the benefit would be that personal data can flow from the 28 EU member states plus the EEA countries to third countries with adequacy without the need for further legal safeguards. This would certainly reduce the regulatory burden for many companies. So on the 15th of December 2015, the Korean government announced that it would revise Korean data protection law to meet EU privacy standards and would apply for the Commission's adequacy assessment in the course of 2016 with a goal to obtain approval in the second half of 2017. If all goes according to plan, Korea may become the first Asian country to obtain adequacy from the European Commission. So far, as Isabelle mentioned, the Commission has granted adequacy to 11 country regimes, including Argentina, Canada, Israel, New Zealand, Switzerland, and Uruguay. For some years, I know that Australia and Japan were apparently looking to be recognized as adequate, and then as Professor Miyashita mentioned, that Japan also has expressed interest. for advocacy. I don't know whether they stand now, but yeah, perhaps other speakers could add some more information later. So it may or may not look straightforward, but I guess part of the challenge for Korea would be to accommodate the dynamic steps that are taking place during the process, especially in Europe. For example, this involves the ongoing discussions about how to revise the Safe Harbor Agreement, and also importantly, the implementation of the EU General Data Protection Regulation, GDPR. So the Korean government, as far as I know, has not yet announced specific reform proposals on substance, but I guess possible substantive issues to be considered could include the following. First, considering that the GDPR seems likely to be up and running as early as 2018, as some people expect, what should be the substantive criteria for the adequacy assessment for the Korean privacy law? Should they be tested under the GDPR or the current directive 9546 or both? Second, harmonizing the different legal regimes between the US and Korea won't be easy. For example, Korea's cross-border transfer typically relies on individual consent, whereas, as we know, the EU has a quite different system. The sanctions also differ. Korea has both administrative and criminal sanctions, the latter of which do not exist in the EU's GDPR or the current directive. And third, national security. This may be different per country and region, but Korea certainly is not free from national security concerns. So, despite some potential concerns, I think that this move is a forward-looking one. If successful, it should help Korean companies gain European consumers' trust regarding privacy. And I hope that we can hear about the progress with lots of exciting new developments at next year's CPDP conference. And then on that note, I'll finish my presentation. Thank you very much.
Thank you very much. I would like to pass the floor to Mr. Takeshige Sugimoto, who is a senior associate in the Brussels office of WilmerHale and Door. He advises Japanese and multinational companies on data protection law and general compliance issues. And he will now present us on the practices of data transfers in Japan.
Thank you. So I am a practicing attorney at a private practice. So my focus on this topic should be the Japanese companies' practice to deal with the data transfer issue rather than governmental negotiation. I will touch upon that topic as well. But since I have been working with so many Japanese companies on data protection, I have a bit of knowledge on what they are doing to comply with the European data protection law. So let me start with the overview. So the impact of the Schrems judgment is massive for Japanese companies to know the European Data Protection Authority are now confident in enforcing the data transfer restriction in practice. So in the past, there has been not much enforcement on the data transfer infringement, but from now on, you have the judgment of the Court of Justice, and so you have sort of certification from the highest court of European Union. So that's why Japanese companies now think that there will be a big enforcement environment change. So after the this Schrems judgment, there will be real enforcement risk in terms of data transfer infringement, regulation infringement. So that's why, and on top of that, Japanese companies, now know the sanction under the DDPR of infringement of the data transfer restriction is up to 4% of global turnover. This is, normally equivalent to the profit ratio of the Japanese companies if they are successful in that year. So that's why, even for management level Japanese people, it's very easy to understand how serious this data transfer infringement risk is under the GDPR. So, but right now, Japan doesn't have adequacy, as other speakers have already explained. So that's why Japanese companies have understood that they need to, take safeguard measures by themselves, not waiting for, Japanese government getting adequacy decision from the European Commission. Because in my knowledge, it takes at least a few years to get the European Commission's adequacy decision after the official formal application for their adequacy decisions. So this is, basic understanding of Japanese companies about data transfer restrictions risk. So let me explain about adequacy things. So on the issue of the communication between the Japanese government and the European Commission, Japanese officials have already initiated informal discussion with the European Commission to explain about, what is a Japanese data protection law, because, in Japan, we use the Japanese language, so normally you need to translate it into English to explain about it. So normally the Commission doesn't have access to the Japanese data protection law, so the Japanese official needed to start from there to explain about the law and what is a good thing in the Japanese data protection law. But Japan has not yet officially applied for adequacy yet. Because Japanese government is very cautious about the timing to apply for their adequacy. So they would like to ensure that they will get adequacy if they apply for their adequacy decisions. Rather, they do that too quickly. Not to, before ensuring the possibility to get adequacy in a few years. So, Japan has just adopted encouraging amendments to the existing Japanese data protection law last September. So in 2 years, the new Japanese data protection law will be in force. But still, Japanese government is very cautious about applying for the leniency. But the Japanese business people are very keen on getting data transfer, the adequacy from the Commission. And so since Japanese companies have been aware of the real enforcement risk, a lot of Japanese companies have already adopted SCCs to transfer their personal data to Japan, because a lot of Japanese companies have invested so much time and human resource to comply with the European data protection law in terms of data transfer, because apparently they like to centralize the management of the human employees' data. Normally the decision making is taken in Japan, not in Europe. So in some Japanese companies, they have appointed one specific legal department personnel to handle SCC. So because there are a lot of subsidiaries all over the world, in huge Japanese companies, so they like to make sure the compliance of data transfer restrictions. So one person have concluded a lot of SCCs with a lot of different subsidiaries. So that is one way for Japanese company to comply with the data transfer prohibition. And there is one instance which is called framework deed. Framework deed is SCCs with a lot of different data transfer in one agreement, rather than concluding a lot of different SCCs in a lot of different papers. So this is a well-structured form, but I didn't see a lot of examples, but some Japanese company are using this sort of way. And there is one issue about email servers are located in Japan because, for instance, so if Japanese companies have email servers in Japan and they have subsidiaries in Spain and France, and if the employees of Spain send an email to France, in practice, actually, the email goes through Japanese email server before it gets to the French, the inbox of the French employee. So Japanese companies have been aware of that. So that's why some Japanese companies have already started using the cloud computing server based in the EU. And they also have used cloud computing server in Japan. So when they would like to transfer personal data from the EU to Japan, they conclude SCC. Then, but before do that, they minimize the amount of personal data transfer from the EU to Japan. In this way, they can minimize the data protection compliance risk. So there are some Japanese companies which can offer such service, so including Internet Initiative Japan. So this is a sort of leading company to offer this sort of service. But there are some other Japanese companies which would like to follow this approach. And so normally Japanese companies are using SCCs, but some Japanese companies have realized actually they are doing too complicated data transfer from all over the world. So some Japanese companies have been considering adopting BCRs. There is no single Japanese company which have already gotten approval on BCRs yet, but there are some really Japanese companies which are considering adoption of application for the BCRs already. So, for example, the company which would like to get a lot of profit in ICT businesses or IoT businesses, so they have a reason to comply with the European data protection law because that can be very, very influential and that will increase the compliance risk for those companies which are very interested in ICT industries. So speaking of BCR and CBPR, so as Professor Miyashita already explained about it, it is very interesting movement, but still interoperability means basically to equate the requirement of both of these two internal rules. So it's very time-consuming to prepare for application. Form for these two different things. Rather, you would like to, make one single, application form to applying for both of these things. So it doesn't mean, actually, unfortunately, it is not, mutual recognition thing which is currently being discussed. Rather, they are talking about formulating one specific requirement. And consent, so Japanese companies also aware of the risk to use the consent because normally, at any time you can withdraw the consent. So the Japanese companies are using consent to ensure the compliance on top of using SCCs. And for example, internal investigation, you sometimes need to transfer personal data to the other governmental institution. For example, in cartel investigation, you sometimes need to transfer personal data to the US. But in that case, you have a difficulty to conclude SCC. So normally the government will not sign on a SCC. So that's why you'd like to anonymize the personal data in the document. But on top of that, you'd like to make sure the compliance. Then you get the consent from the person, the data subject of the personal data. And so certification, so as Professor Miyashita mentioned, so there is a deep tech which just become an agent, official agent of APEC CBPR. So Japan would like to make this institution to be mutual recognized from the European Commission, but there is still a way to go. So, but still, Japanese government and associations are seeking the future possibility to get a mutual recognition. So code of conduct, so this is a possibility for the industries like pharmaceutical sector to get sectoral rules to comply with the GDPR. For example, pharma sectors have a very difficult issue of clinical trial. So they are required to report to the farmer competent authority about the incident or something. So then you actually need to prepare and get the consent, explicit consent, because normally the clinical trial data contains specialized category of the personal data. So conclusion, so Japanese companies have been using SCCs, but still they are keen on getting adequacy, and Japanese government is very supportive, but they are still very cautious about getting, applying for the adequacy. Thank you very much.
Thank you very much indeed. Our last speaker is Sébastien Gambs. He has joined the University of Québec at Montréal, Canada, as a professor since January 2016, after having held a joint research chair in security of information system between the University of Rennes and INRIA in France. His research interests encompass subjects such as location privacy, privacy-preserving data mining, privacy issues in social networks, as well as privacy-enhancing technologies in general. And Sébastien Gambs will share a comparative analysis of EU and Japanese practices and laws, also with a technology perspective on data transfer.
Thank you. So first I would like to thank I would like to thank Professor Miyashita and CPDP for inviting me. I'm not a lawyer, I'm a computer scientist, but I was several times in Japan because we were working on joint project in terms of privacy between France and Japan. So I know there is a panel tomorrow on discussing the reform of data protection in Japan, so I hope you will also attend this panel, and I hope I will not say any mistakes. I just want to share some elements, including technical ones, about the convergent and divergent that can affect data transfer between EU and Asia. So just to say that in Japan, there was also, in the last year, several cases about some privacy breach. And I think the public in Japan is well aware about privacy issues. So there was a case in 2013 about Suica, which is actually the transport card in Japan, where the data was sold to a company for analysis. And if you look at the data, they were supposed to be anonymized, but the definition of anonymous includes a lot of attributes that are quasi-identified and that could be used to re-identify the users. And also in 2014, there was another big case about data from a company called Beneze that was sold to list broker, including data of millions of customers. So I think the public in Japan now is well aware about some privacy issue. If you look at the consequence, were very important for the company in terms of reputation. And also the CEO has to do a public apology, which I think in Japan is a big issue. If you and in terms of finance, voucher was sent to customers. So as it was already said by the previous speakers, the data protection law in Japan was reformed in last September. I think there is a lot of points where Asia and Europe are converging if you look at amendment. So for instance, now there is a creation of a data protection authority. The scope of what is considered to be personal information has been broadened quite a lot. And there is an harmonization of the internal framework. What is interesting for me is if you look at the motivation about why changing privacy law, one of the motivation is actually sometimes privacy law is seen as a barrier for big data. So if I was looking at some of the documents, it was called the current regulation was a barrier to the utilization of personal data. So this was, at the same time, it's also the law has been reformed to allow more use of the data, and it's a quite different motivation sometimes of saying to enhance privacy, right? Just so some technical points where there is really difference between Europe and Japan, and if you look at what is the definition of anonymous data, in the Japan privacy law, so personal data is, so anonymous data is personal data which is not able to identify the individual and is not able to restore it by deleting the description containing the personal information or by deleting all the personal identifier content in the personal data. So this is quite, I would say, more simple than if you look at what you would have in the European regulation, where you have to look at all the technical means about the cost, also about the technology to be able to re-identify people. So I will say the definition is really more simple, and there could be a case of quasi-identifiers that you would miss if you apply this definition. So I think what is anonymous data in Europe and Japan, there's quite a lot of difference on this topic. And at the same time, I'm very proud to say that, to the best of my knowledge, the Japanese was the first one to do anonymization competition. So to do, in a national conference in computer science, a competition where they were trying to evaluate the effectiveness of anonymization algorithm. So I think also people are trying at the same time to understand how anonymization works. And so this is the competition which is called Ice and Fire. I think it's a very good thing to try to do at a larger scale, for instance, at an international level. Another point, if you look at the difference between Europe and Japan, is how you earn trust. So in the European regulations, there is lots of things such as doing a privacy impact assessment and showing that you are really trying to implement privacy, to do privacy by design. In the Japanese system, so privacy is also a cultural norm. So of course there is different. It's more that by default companies and government have a lot of trust from users. So I don't think there is so much tools as you would have in the European regulation to show that you really complied with privacy. But the consequence, if you have a privacy breach, can be huge, not necessarily in terms of finance, but in terms of reputation. And then reputation is a really an important issue in the Japanese culture. So it's also as consequent financially, because you might have users that leave the company. So this also is a very different. What are the tools that will be implemented in the regulation to really show that the technology or the implementation is respecting privacy by design? And just to conclude, also there is some rights that I'm not sure if they will appear or not in the regulation in Japan, but there was some Yahoo! Japan was proposing to do some kind of right to be forgotten in the same vein as Google was doing of not referencing data. So the criteria that are used to decide whether or not this right should be applied also should be looked at to see if technically there's the same or not between Europe and Japan. So this is just to say a few elements where I think there is really a big difference between the two countries.
Well, thank you very much. Thank you to all panelists for this very complete overview. I would just like to come back again to this question of the Schrems case, especially because Professor Munir left it for a second round, and we were asking the question, are the laws actually in Asia adequate? And there is this question now that we see that with the judgment, okay, there is the question of the adequacy on the one part that asks you to look at the whole legal environment, not only about what is the data protection law, but actually does that country has other laws that actually might impact and actually interfere with those fundamental rights that are guaranteed somehow in that data protection law in that country. And I would like to know more about that, if you know about that, or at the moment, do you know about any assessment that is being conducted, for example, in those countries to evaluate their general legal system? And also, can we think about specific ways to improve if things need to be improved, for instance?
Thank you very much for the questions. The adequacy issue, as we know very well that under Article 25 of the EU Directive, there are two main things that needs to be assessed on the law of a particular country in deciding adequacy issue. One is, of course, as we know, the content of the law, and the other is, of course, how the law is being enforced. I can speak for Malaysia and for Singapore, because these two countries, as far as the law of those countries are concerned, they have a very peculiar element in it. If you look at Malaysia, for example, the law, data protection law of Malaysia does not apply to certain sectors. Specifically, the law in Malaysia does not apply to federal and state governments. Malaysia adopted federal and state governments system. So specifically, the data protection law exempt or exclude federal and state governments. And I can foresee that would be an issue as far as adequacy assessment is concerned. The other problem with the Malaysian law is that it applies only to commercial matters or commercial transactions. Or in other words, the law does not apply to non-commercial transactions. This could be another potential issue or problem as far as adequacy assessment is concerned. And the other main issue is that the fact that the regulator or the supervisory authority in Malaysia, if I may be blunt or honest with you, is not that independent. It is appointed by the minister, accountable to the minister, and they have to report to the minister. The minister can appoint them, the minister can ask them to leave the office. Basically, the power to hire and fire is with the minister. As far as Singapore is concerned, there is one particular issue as far as data protection law of Singapore is concerned. Again, the issue is that it does not apply to public sector. So the law in Singapore does not apply to public sector. And I was made to understand that there is a separate kind of rule applies to the public sector in Singapore with regards to the processing of personal data. And I was made to understand it is in the form of directive issued by the Ministry of Finance. The question is this, whether or not this directive issued by the Ministry of Finance is compatible with the data protection law of Singapore. Because I was made to understand, because this is a secret document, it seems, but some friends in Singapore were able to tell me about the content of the directive. There is no remedy available if anything happened. There is no enforcement mechanism, and a few other things which are lacking in that directive. So that's my comment as far as Malaysia and Singapore are concerned with regards to adequacy issue.
Do you want to complement for your respective practices in your countries, or?
I think for Japanese government, so they're cautious about applying for the adequacies because they are currently thinking about reforming the data protection law for a governmental side. So that is one issue which Japanese government have. And so to strengthen the data protection law against the government, Japanese governmental institutions. And another issue is that the exception for the public security. So Japanese government is considering whether they should carve out the exception more and more to follow the Schrems judgment, because one of the big reasoning in that judgment is to invalidate the safe harbor was that public security issue. So the U.S. government can extract, do the max extraction of personal data from the company. So that was, I think, one of the biggest reasoning. So that's why Japan also, is examining whether it's necessary to do additional carving out of the exception.
Can I add? And with this TPPA that has been concluded and data protection issue in relation to Chapter 14 of the TPPA, And this, with the issue of safe harbor has been declared invalid, I think it is quite interesting how countries in Asia perceive the decision of Schrems with regard to safe harbor. Because recently I had a very interesting conversation with the regulator in Malaysia, asking him what would be the impact of the Schrems case as far as Malaysian companies are concerned. And interestingly, the regulator was telling me, no, there is no specific impact. I was puzzled by that comment, the fact that there are impacts certainly on Malaysian companies doing business in America, because unlike Israel, as we know, Israel has issued, the regulator in Israel has issued a kind of directive that Israel companies cannot use safe harbor to transfer data. We don't have such thing in Malaysia, Singapore yet. A specific directive issued by the regulator. But of course, as I said, with this TPPA, this issue of safe harbor, whether safe harbor is safe, becomes very contentious.
Thank you. I would like to gather questions from the floor if anyone has particular questions to our very fine panel here and expert. Yes, please.
Hello, my name is Georgios Petropoulos. I'm visiting fellow at Bruegel. I have two questions. First of all, congratulations for this very interesting and informative discussion. The first one is the ECJ decision basically said that there is no adequate protection of data in US. What is the view of Asian countries about that? Is there adequate protection in US soil? Second question, from 2000, EU and US had a safe harbor agreement, but such an agreement was not the case between EU and Asian countries. In your view, does this create an element of unfair competition of Asian and US companies in Europe? Thank you.
I will take a few questions and then we will answer together.
Mimi came from University of Brussels. Just a couple of questions. You have talked about data transfer from EU to Asian countries. You haven't talked about actually the other direction, I think, which is quite related to actually trade. As you know, a few years ago, under the FTA that Ms. Kim mentioned, the FTA between South Korea and EU, the first actually financial data transfer occurred between EU and South Korea, and there were a number of issues involved actually implementing the data transfer. For example, when it was actually a data transfer provision included, it was way before this actually explosion of data transfer actually occurring right now. And I just wonder, for example, in trade, it's obviously data transfer is very, very important, particularly Korea and Japan, from the EU's point of view. And let's say, for example, financial services, particularly banking, or even like other insurance, for example, or services, they wanted to import data from, let's say, South Korea to European active banking headquarters, such as Standard Charters. Now, most of these data are not actually, they could have transferred to Europe, but most of the data are stored somewhere in India on big actually server, right? So how do you deal with this issue? If something happens, data clouding, actually data server in India, how would you actually solve these actually protection or privacy issues, for example? And of course, these data servers are actually serviced by American companies. So I think there's a lot of actual complexity involved in it. That's my number one question, if actually Japan and Korea have found the different ways to do business with the European multinationals. My number two question is concerning, for example, the global governance issue. As you know, the Real Active Good Friends Club at TISA is looking at this data transfer in the service sector. Now, in terms of coordinating globally, not only EU and Asia, but looking at TTIP and also TPP, all that, how do you see actually a globally governing actually bodies evolving from here? I don't know whether EU has, I understand the EU supports what's going on with actually RGF club at TISA, but how active and proactive EU is or Asian countries in terms of coordinating, if you will, and drafting global governance issues concerning data transfer. Thank you.
Do you want already to answer these questions and we'll take more afterwards?
Can I ask another question? My name is Hee-Eun. I'm from Delft University of Technology. I have a question regarding the difference between the EU and China and the data production regime, because we have a lot of discussion just now regarding the Japanese and the Korea or South Asian countries case, but we kind of ignored the China's case. And so what would be, I have two questions. First one would be, what is the biggest difference of data protection regime between China and EU? The second one is, what would be the potential impacts after implementation of GDPR in European country? Thank you.
Thank you. We will stop here for the question for now, and I will let the panelists answer the question.
Let me try to answer a question on China. Based on my research and based on what I have published last year, for the audience, I have published a book on data protection law in Asia, December 2015, covering Malaysia, Singapore, Korea, Japan, China, India, and a few other countries like Hong Kong, Taiwan. So it was published by Thomson Reuters in Hong Kong end of last year. So based on my research, China has got, the data protection law of China is scattered around. It's scattered around a little bit here and there. There are so many legislation that have been issued by the ministries in China and by local authorities in China. So to sum up, the position in China is that the law is scattered around. A little bit here, a little bit here, a little bit there, a little bit here. There was an attempt, I think a couple of years ago, there was an attempt by the Chinese government to introduce a comprehensive data protection law. And there is a draft. I think the draft is available online. And I don't know, for whatever reasons, it didn't happen. Yeah? And I know the drafters of that draft law. But when I asked them recently, when I met some of the scholars in China about the status of the bill, nobody seems to know the position, whether or not there is any appetite on the part of the Chinese government to reinitiate the bill. So that is the position now in China.
Okay, so I'll try to answer this question about data transfer from Asia to the EU, especially the issues related to the EU-Korea FTA. So yeah, indeed, as part of the implementation of the EU-Korea FTA discussions, some European financial firms complained about Korea's stringent Korean laws that required that had some restrictions about this offshore data processing. There were some localization requirements. I can't remember exactly, but yes, some facilities had to be in Korea. So this issue was raised in the context of the FTA implementation, as part of the FTA implementation issues. But this was also a chance for, I believe that this was also a chance for Korea to upgrade its privacy law. As I mentioned, the transfer mechanism in Korea, they tend to rely on users' consent, which is not really the case in other jurisdictions, for example, in the EU. So issues like this will make Korean law or other Asian privacy law will become more modernized and advanced. And in terms of global governance, yeah, with the increased use of cloud services, it's true that we are kind of everywhere. We have to look at everywhere, but at the same time, nowhere. On the one hand, it's true that with cloud computing services, we're basically nowhere. I mean, we are above the clouds. But at the same time, some countries, they increasingly impose data localization requirements and so on. So our company's approach would be that we try to be, we try to be compliant and try to apply the strictest strategy. So yeah, it's not easy, but that's basically how companies will have to do. They try to be as compliant as possible. Yeah, it's never enough.
Let me briefly answer 4 questions. So I don't think the US can become an adequate jurisdiction until they meet the requirement of the criteria set by the Schrems judgment, which is strictly carving out the mass, ability to do the mass data extraction. But under the Obama administration, I don't think it's very, it's likely to, that things happen. So it probably takes time, and if they do get a safe harbor again, so it will be invalidated, based on this judgment. And second question, I think it was not fair for other companies, except for the U.S., to see the safe harbor decision. Because for Korea, for Japanese, we need to try to get adequacy from the Commission. So now the situation for everybody is fair in terms of data transfer. And so the question on the data transfer from Japan to the EU, this is a subject of the Japanese data protection law, but normally the EU should have been regarded as an adequate protection jurisdiction, so normally it's not probably difficult to transfer data from Japan to the EU. And data center issue, so India is not regarded as adequate jurisdiction. So then if, for example, Korea get adequacy, then the data transfer will be transferred from India to Korea because it's much cost effective to store the data in Korea. So right now there has not been a lot of enforcement in terms of the data transfer prohibition, but from now on you have much more severe the enforcement risk. So companies will probably think about the risk more seriously.
We will conclude here the panel view of the time. I would like to get some final remarks from the panelists if they have any to share.
To sum up, there is no problem to transfer data from Europe to Asia. Sorry, from Asia to Europe, because the laws of those countries allows the data to be transferred, and we know very well that EU directive has set a very high standard. The problem is to transfer data from Europe to Asia. That is the problem, especially countries that I've mentioned just now, Singapore, Malaysia, and the Philippines. Whether or not the rules set by the countries are adequate. That's my last point.
Enforcement, I think enforcement environment in terms of data transfer restriction will be completely changed in the next 2 years, running from the European competition law enforcement conducted by the European Commission. So there will be 28 different supervisory authorities which can have ability to impose huge, massive amount of fine on infringement of the data protection law. So I think such change will happen for every single company.
Yeah, I totally agree with Takeshige's comment. We'll see more enforcement by the European authorities, and it's not just the level of fines that is of concern, but also related reputational risk and possible follow-on litigation risk. So yeah, for companies, this will be a big concern for the next coming years, especially in Europe.
Also, one issue that I didn't talk is about the encryption level and the national security in each country also when you transfer the data. So is it the case that the data is encrypted with an encryption standard that is strong enough with no backdoor, and always a conflict with the national security issues also an important thing to consider when you do data transfer, I think, between EU and Asia.
Well, thank you very much, everyone. As far as I know, this is the first panel during 9 years of CPDP, consisting of 3 different Asian jurisdictions and 2 experts from European continent. So thank you very much, and this is a very punctual panel. We've finished now. Thank you very much. Thank you for joining. Yes, thank you.